Clear and plain language, according to Article 12, it's not optional anymore. It applies to everything, notices, policies, agreements, and it's the legal basis for legal design in privacy. Clarity is a legal obligation, not just a nice to have. And yet, as privacy professionals and lawyers, we still tend to write like we're paid by the syllable. I feel like whenever we're writing legal information, it will be easy to write everything I know about the subject. I kind of want to shine and show the world that, okay, I know this and these little details. But I should be writing from the point of view what my end user and the data subject wants to know and needs to know, instead of writing essays about my own knowledge. So if we look at the typical day of a privacy notice and website users, let's walk step by step through what the typical user experience actually looks like in practice. First, the user lands on a website. Immediately, they are greeted by a cookie banner, often with a big, bright button saying, accept all. And if they're curious enough to look for more information, they might find a privacy notice somewhere tucked away, written in 8-point font, so small that you'll need a magnifying glass to be able to read it. And the notice, it's often almost 5,000 words, heavy legal language. So the users, they will bounce, they won't read the information because it's not designed to be read. And real people, they don't have time to decode a mystery novel just to understand how their data is handled. So when we wrap privacy information in legalese, we don't just risk non-compliance, we actually lose trust from the people and the users. People think that if they can't explain clearly about how they are going to use my data and where the data goes, can I really trust them as a company? Probably not. So legalese doesn't just create confusion, it creates low engagement and ultimately damages credibility. And remember the Linklater study, you have 48 seconds to impress these people. It might sound impossible, but we'll look at later like how to actually make it work. And when people are bombarded with too many unclear options, like dozens of toggles or endless categories of data, they experience something called cognitive overload. And this often leads to decision fatigue. And their mental energy depletes, and they end up granting broad permissions simply just to finish the process. I mean, we all want to click accept all just to be able to do the things we want to do on the website instead of reading all the information about cookies and privacy. And when information exceeds the amount our brain is actually designed to handle, we stop processing details. In privacy, this means that people abandon critical thinking and default to the easiest path, whether that's granting permissions or ignoring important settings. So finally, we're talking about legal design and what that is. And as I mentioned, it means incorporating design thinking into law. So we can design information, that's something we quite often see already, and then we can redesign services and products and even legal systems. And the aim of legal design is to find an innovative way to explain law that it makes it more interesting for the end users and data subjects here. It'll make it easier to understand and it'll make it more accessible. Like, it's basically this user-centered approach to law. We basically put the people back into the center of the legal concept. And often we see statements that legal design is something quite newly discovered, maybe around 2015. But that's not true in a way. Like we've seen these requirements for more understandable law throughout the history. I mean, the term legal design is fairly new, but the requirements for more understandable law has always been there. Like in a way, the pleading in English Act in as early as 1362 in England stipulated that all pleas shall be pleaded and charged in English instead of French, because most of the common people, they didn't speak a word of French, but still the court proceedings were in French, and that was impossible for them to understand. That later led to another act saying that all the governmental information should be written in English instead of French. And then if we look at Sweden, Finland, we used to be part of Sweden back in the day. In the 18th century, some of the legislation was written in the form of poems, because not everybody could read, and we had the language issue, like all the official information was in Swedish. The Finnish side of the country didn't speak a word of Swedish, they couldn't read, maybe even in Finnish. So the legislator thought that some of the legislation is so important that everybody should know it, so they wrote it in the forms of poems to help people memorize it by heart. That's a bit crazy to learn, like teach people to memorize law by heart, but that was one way to make the information accessible for everybody. Then moving on to 1956, when Lord Dunning here in England introduced the idea of big red hand, meaning that the more unreasonable or onerous the clause of the information, the greater the notice or attention which must be given of it. And Lord Denning later confirmed this in the famous case of Thornton versus Shoe Lane Parking in 1971. And this is a strong point established under English law to use visuals to help people understand the complex legal information. Then in the early 80s, the actual term of legal design was introduced in the academic research by Ms. Colette Brunswick in Zurich University in Switzerland. And I think Colette was really ahead of her time, because she also introduced the concept of humanoid robots being legal designers. And I think that'll be something we might see after the age of AI agent era, so it might still be coming.